At the top of the list is a durable power of attorney. This gives the family provision for the management of their finances and personal affairs in the event that the signer of the power of attorney loses competency, or just for convenience sake, if they prefer a child or the other spouse be doing all the business, the durable power of attorney allows that. The durable aspect of the power of attorney is a simple statement that even if the creator of the power loses mental competency, the power granted in the document will continue. Second on the list will be a health care representative proxy. If you are in the hospital and because of medication or injury or illness, you are unable to make medical decisions for yourself, the legislature has allowed you as a citizen of the state of Connecticut to designate somebody to speak for you. This document works hand in glove with the living will, which is your statement of what you want for treatment and what you don't want for treatment if death is imminent or if you're in a permanent coma. The legislature, well, for instance, when my mother was dying from congestive heart failure, the legislature had not authorized Connecticut residents to have a living will. She was rushed from Mystic to Lawrence Memorial Hospital having a heart episode where her heart stopped. By law, the physicians were required to put the paddles on her chest. They hit her 3 times with increasing voltage and eventually was able to get her heart started, giving her 1 more week of absolute misery. This is the type of thing that the living will can prevent. And of course, the central document to put any estate plan into effect will be the last will and testament. You can't go to the internet and download a Connecticut will that's going to protect your assets. On the subject of protection of assets, a lot of our plans use testamentary trusts. Testamentary trusts are ones contained and created in your last will and testament. You can change them or modify them at any time during your life so long as you still have mental competency. The federal law exempts testamentary trust from consideration in determining eligibility. Consequently, if a spouse leaves all his or her property to the other spouse in trust under the will, those assets have to be ignored in a Title 19 application. If a death is imminent, we can transfer all the assets to the patient, and the patient's testamentary trust will protect everything in the event that the surviving spouse, the community spouse, ends up needing long-term care.
I think one of the concerns we hear a lot about is this revocable living trust. Very, very different animal than a testamentary trust. So again, revocable living trust, not a trust that can be used for Medicaid planning, as opposed to a testamentary trust after death. So a little bit of a difference there. Again, that probably run another segment alone about just talking about living trust or revocable living trust. Under the documents that Jim just mentioned earlier with regards to the durable power of attorney, I think it's very critical, and I've seen this now over the last couple of weeks. I think it's extremely critical that the person giving the power to his or her attorney, in fact, not necessarily your own attorney, but the person that you're giving the power to, you've got to be very specific as to when does the power go into effect. Technically, the statute says here in Connecticut it goes into effect as soon as it's signed. However, it has to be presented to the child, let's say, or to your attorney in fact. And there've got to be very clear and specific instructions when to do that. For example, I've got a client right now, very independent, single man, 85 years old, young, I should say, and absolutely refuses to give his power of attorney over to the designated attorney in fact. Again, this is something that we went over quite extensively in our intake, and I think that needs to be explained very well and understood by the client. Also, I think once you sign or get these documents, I think it's important to mention that healthcare proxies and living wills, facilities like a hospital will have their own forms. So it's very, very critical that you not sign their form if you've already gotten these documents or have these documents prepared, because the newer document will supersede anything that you've done perhaps with an elder law specialist.